Thank you very much, Priya, and very pleased to be here, and thankful to the Australia-India Institute for providing me this opportunity to speak about a subject which is very close to my heart. The topic, as was introduced by Priya, was to speak about competition reforms in India. Since the time, I hope you can hear me.
No.
Beg your pardon, a little louder? That's not a problem. No, this is a microphone for the live streaming, not for a public address system here. So let me speak a little louder, and if you can't hear me, please don't hesitate to draw my attention. The journey of India in promoting competition began in 1969 by virtue of a constitutional provision which required the state under the what I call the directive principles to ensure that there is no concentration of economic power and that resources, common resources, are available for widespread consumption or utilization, or whichever way you call it. Now, in those days, until 1990s, very large number of developing countries were influenced by the Soviet model of central planning, or what is called command and control systems, where majority of manufacturing or production of goods and services were in the state sector, run and operated by the state. Whether you look at, I'm not talking about traditional areas like railways, which continues to be in the state sector in most countries, I would say, including in India, but things like telecom services, insurance services, airline services, and 101 other things, telecom services and so on, electricity, etc., were all produced, generated, and distributed by state companies, with the result that the efficiency was low, and most of these companies often lost money. Most of them were losing, in spite of the fact that they enjoyed a monopoly, but surely because of the inherent structure of state-owned enterprises in many cases, which never faced any competition. Now, 1991 was the turning point in the reforms history of India, and 1990 was, in fact, that was the time when a very large number of developing countries turned towards a market economy from a command and control system, which was accelerated by the arrival of the WTO in 1995. We knew, the world knew that by 1994, April 94, that the WTO is going to come into being. So you had this very huge external force behind pushing countries to adopt a market economy. As I said, on its own realization, India had a competition law of a type, of a sort, in 1969, which is basically to control monopolies based upon what I had said a little earlier, the constitutional provision of checking concentration of economic power. So therefore, its focus was mainly on licensing industries so that they don't grow big. Big was bad. That was the kind of political philosophy, including profit is a dirty word. Those are the two very guiding principles of command and control economy as far as the private sector is concerned. It doesn't matter whether the state loses or not, as far as the taxpayer is there, the budget is there to fill the gap. 1990, India underwent severe crisis, financial crisis. Our foreign exchange reserves fell to about 7 days import bill, and that is the time. But there was even a time when India had to mortgage its gold, about 150 tons of gold, to Bank of England in order to raise that kind of foreign exchange. And it became a very major scandal in India. You can well imagine the kind of emotion that's particularly Indians and many South Asians have Gold is, I mean, India still today has the highest gold holding in the world in terms of the people hold, because gold is considered to be very. So you can well imagine if 150 tons of gold were shipped out to Bank of England in London, and let's not forget there was a colonial pitch on it as well. We had gained independence from Britain in 1947, and the relationship has been both good and bad. Generally, it has been good, but still, that issue about the kind of bankruptcy which the Treasury faced, and the fact is that you had to borrow from Bank of England in order to meet with the kind of exigencies which arose. It was a major scandal. It was a major talking point in India. And at that point of time, we had a finance minister called Dr. Manmohan Singh. You might have heard of him. He used to be the Prime Minister of India for 10 years, from 2004 to 2014. And was reputed to be the most educated Prime Minister in the world, being a PhD in economics and so on. He was the then Finance Minister and had a very capable Prime Minister at that time, Narasimha Rao. So they both decided that it is time for us to unlock the Indian economy. We cannot continue on the same path. So several trade and financial sector legislations were removed. All the controls, etc., were removed. And one of them was the Competition Act, which I spoke about, the Monopolies and Restricted Trade Practices Act, which had a merger provision, and that merger provision was taken out. Merger regulation. Now look, you don't need to regulate mergers. In a globalizing world, our firms are anyway small, so where is the problem? That is how the situation was when reforms were adopted in 1991, which included the amendment and including bringing about many pro-competitive reforms in other existing laws, not just the competition law itself. The Foreign Exchange Regulation Act was scrapped. A new law was passed. It was terrible, foreign exchange. I mean, I remember at that point of time, since we were very starved of foreign exchange, that if I had to travel to Australia, I could buy my ticket in Indian rupees, but I would be getting only $8 as foreign exchange allowance for me to travel. You can well imagine on $8 I can hardly do anything at all. And of course, all that led to a very big black market in foreign exchange and many other things. But just to give you a flavor of the time that we had, that even a telephone line connection was difficult to get. You can't imagine, though, you didn't have mobile phones those days, what you have now. Getting a cooking gas cylinder was a problem, unless you knew somebody or you bribed somebody. And, so this scene was quite, that led to the formation of our organization also in 1984, in order to deal with these kind of problems. Now, if you look at the historical manner in which economic governance took place in India, we had an industrial policy resolution of 1948, amended in 1956, which stressed highly upon government intervention and government regulation. As a result of which, as I said, the competition law, as it was called, the Monopolies and Restricted Trade Practices Act, was designed and adopted, but it was, as I said, it was a licensing law. I mean, if a company was given a license to make 10,000 widgets, it dare not produce 10,001 widget. That was the kind of regulation which existed. And the state and the mandarins who ran the economic governance system believed that this is how they are allocating resources in a fair manner, so that there's a widespread welfare to the and public sector was the commanding heights of the economy. So huge public sector companies were floated, factories to make machines and so on and so forth. Yet some amount of private enterprise was allowed. Maybe 20% of the GDP was, in terms of the investment, about 20% would have been in the private hands. Very few foreign companies were allowed. some who were there by legacy, like Coca-Cola, for example, which was thrown out in 1977 for other reasons. So very few. Unilever was one of the major consumer goods companies which had been in India since a long time, so they continued. And so there was similarly, and Indian enterprises were again, as I said, there were a couple of big business houses like Birlas or Tatas. Those days, Birlas was allowed to make automobiles, Tatas were not allowed to make automobiles. And Tatas made trucks, but not cars, those days. Tatas were able to make steel even during the British times, which was very surprising, but they did. In the current licensing regime, the industrial policy resolution I spoke about, Birlas were not given a license to make steel. They said, we don't need this kind of competition. So you can well imagine the kind of history that we had. There was a February 1964, a famous mathematician, Mahalanobis of India, who was not a trained economist, but one of the best economists that India had, found that the top 10% population had cornered 40% of the income because of all these restrictions that I spoke about. There was a Monopolies Inquiry Commission in October 1965, which found that there are few business houses were controlling a large number of companies and large-scale restrictive and monopolistic trade practices existed. This is the committee which had drafted the Monopolies and Restricted Trade Practices Act. The 1967 an Industries Development and Regulation Act was, when it was examined, it found disproportionate growth of big business houses. So the big business houses had the advantage of crony capitalism in the sense that they could get their licenses, permits, quotas, etc., etc. And there are some very funny stories. So 1969, the Monopolies and Restricted Trade Practices Act was adopted, followed by the Foreign Exchange Regulation Act in 1973. Very restrictive, and I gave you an example. And over much of 1960s and 70s, we had a growth rate of 3.5%. It was so bad, and poverty only continued to increase. And that is what we call the Hindu rate of growth, named by a very famous Indian economist, Krishna Raj, who incidentally used to teach in Jaipur, the Rajasthan University, and had taught my colleagues as well. 1991, 1995, I spoke about, these are the turning points in our economic history. In 1996, following the discussions at the WTO at the what is called the first ministerial conference in Singapore in December 1996, which spoke about looking at the inter-overlap or the interlinkages between trade and competition policy, among other things. Trade and investment policy was another one, and so on. That the government adopted, the government also set up an internal committee in 1999 to examine the validity of the Monopolies and Restricted Trade Practices Act and whether a new competition law is required. And speaking modestly, most of this drive was provided by the consumer movement, which is led by us, as against the business. I mean, businesses hate competition law. They feel that it is a millstone around their neck. They can't do the way they want to do, including rip off you, me, and everyone else. Now, 1990, in May 2000, the committee placed a concept bill, and it was followed by the Competition Act adopted in 2002, but it was dysfunctional because of the kind of people who were appointed on the commission. And the Supreme Court felt that there should have been a judge to lead this body rather than a bureaucrat. And an amendment act was then passed in 2007 to split the commission into two bodies, a regulatory commission and an appellate tribunal. And the appellate tribunal was headed by a judge. So that was a kind of trade-off between the government and the Supreme Court that look fine. Here you are. The ultimate repository of any adjudication would rest with a judge. And this was, the Supreme Court felt that this is sort of a travesty in the sense that it goes against the doctrine of separation of powers between judiciary and the executive. Now, in the interlude, the reforms adopted in 1991 saw an unleashing of the economic forces in the country. I gave you several examples. Merger regulations were dropped. Growth rates went up to 7 to 8%, from 2 decades growth rate of 3.5%. Even touched 9% also. And all because of the kind of various competition reforms, including competition law reforms, which happened. And every government now, as against in the past, when competition was a word which was frowned upon, has now started speaking about the slogan of competition in order to ensure that we have a productive economy. So there was a sea change in the whole thinking, including the new act when big was no longer bad. The new act, like following any other law, was that big is not bad, but the abuse of bigness could be bad, and that can be taken care of. Kind of romantic Fabian socialism by our very beloved Prime Minister for long years, Jawaharlal Nehru, who was a Fabian socialist. He believed, for him, actually, big was bad and profit was a dirty word, and believed in the commanding heights of the Indian economy. So, you can well imagine the kind of sea change, and even Australia has undergone quite tectonic changes in 1980s. From the same kind of protectionist, autarkic regime to more open regime competitors. In 2006-2007, we did a competition perception index, prepared one on the basis of purposive sampling of nearly 600 respondents from various sectors, which showed that 54.7% people are aware that competition has increased substantially. However, 47.4% believe that government policies are themselves restrictive and do not promote competition, while 43.2% people believe that the existing market regulatory laws are ineffective. Now, when the new law was being adopted, let me speak about some myths and realities. As it happens, whenever there is a change which is happening, there are doubting Thomases in this society. And there is always a downside to everything possible. When the new competition law is being adopted, there was a heated debate. Also, because there was a discussion happening in Geneva at the level of the WTO with which India did not agree on trade and competition policy. And different stakeholders have always looked upon competition policy and law differently. While policymakers consider competition policy synonymous with competition law, business classes take it all as a threat to their existing businesses. Many in the civil society look at it as another market access push by Western countries to open up our markets. This is a very important point which I would like to make, that in many developing countries, civil society opposed competition reforms because they felt it is a market access push by companies coming from Australia, Europe, or US, or wherever. That's fine. They are asking for a level playing field, while our own industries, our own enterprises are too small. They are not yet so competent, and therefore we cannot have a competition. That is the kind of thing. The reality is the effect of foreign entry into the market depends on the capabilities of domestic firms. If anything, I believe that a well-designed and effectively implemented competition law in a developing country provides protection to domestic firms from foreign firms that use anti-competitive practices to capture the national market. And there are various examples of this which we have used in our research and been able to get the message across to many developing countries to adopt a competition law in spite of their own civil society arguing against it. The last of the recalcitrant countries is Bangladesh, which has just adopted a competition law. I mean, there are instances and experiences from various countries where multinationals had to pay heavy fines for their anti-competitive practices. One of these is the vitamins cartel, the international vitamins cartel, where several leading and sophisticated drug manufacturers were involved in a global conspiracy to fix the prices of bulk vitamins, which go as sort of raw materials to make vitamin formulations. Action was taken against the cartel in US, Canada and Australia, as a result of which a fine of over $1 billion was levied on the perpetrators. Even Brazil took action on it after getting cooperation from the US, with which Brazil has an agreement. However, India could not take any action. This is in spite of the fact that we brought it to the attention of the erstwhile MRTP Commission. The MRTP Commission said, we don't have the capacity to be able to deal with it. I said, at least you should make the effort, which they did not. They had made an effort against a foreign cartel and burned their hands, and therefore they were very shy of doing something which is, and because the Supreme Court of India had struck down an order they had passed on a American natural soda ash cartel, saying that you do not have extraterritorial jurisdiction. The cartelizing agreement has been done in the US, and therefore whatever action you take is ultra vires of the law. It doesn't stand in the law. And today the new Competition Act has this kind of provision, and we are, the country is investigating certain foreign mergers which do not have their legal status in India but are operating in India. So the Competition Commission is reviewing that on the basis of what we call the extraterritorial jurisdiction based on the effects doctrine. That if anything happens outside, anything happens in Australia and New Zealand has an impact on the Indian market, the Indian Competition Authority has a right to investigate it or to prosecute it also. So, I mean, these are the kind of realities. This is what we were taking to people, that look, this is not, and as the famous economist Joe Stiglitz has also said, competition policy is not a luxury, it's a necessity for developing countries, and that is the argument which we were able to put forward in large number of developing countries where we've been working, not only in India but in Africa and Asia, and have been successful. As I said, the latest example was Bangladesh. We've been working for a long time in order to get rid of these kind of misconceptions that competition reform is not necessarily meant to allow access to foreign companies, but it is there to regulate your own market, to protect your own consumers, your own economy as well, and to see to it that a benefit. Now, another myth is competition policy and law are tools for the rich and urban societies. I gave you the famous quote of Joseph Stiglitz, who said this, but in order to buttress that statement, or I mean, give many examples. I can give one example in our own work. There was a poor, elderly, illiterate widow who lives in a village near Chittorgarh in southern Rajasthan. I don't know if you're familiar with Rajasthan. The famous cities are Jaipur, capital where I live, and Udaipur. And this. Now, she did not. She had to sow her unirrigated 5 biga farm. 5 biga is about 2-acre farm. In time, sowing has to be done in time. Otherwise, if you lose that time, you miss the bus. But did not have the resources to buy the seeds, so she went to a district cooperative bank to take a loan to buy the seeds and fertilizers, etc., to use on her farm. Now, certain procedural changes had taken place because of the kind of corruption in the system, that any borrower has to affix his or her photograph on the loan documents. so that you can identify the person. Fair enough. Now, what was happening, there were just 2 photography studios in that little town next to her village. And they were working in cahoots. They would sort of exploit the poor illiterate people. And she went and paid 15 rupees was the cost of 5 copies of her passport photo. And the fellow would not deliver it in time. She went to the other studio hoping that, the other studio knew that this lady had gone and got her pictures done there because they were both working in cahoots. Sorry, I don't have a film or whatever, you give some silly excuse. So finally the studio said, you give me 200 rupees for a bill of 15 rupees. Just pure exploitation. As it happens in any society like this where people are ignorant. And then she happened to come across one of her networkers who then took her to the consumer court, which also deals with retail level anti-competitive abuses like this. And that studio was hammered. He had to pay a big fine, and that fine, about 500 rupees, was then given to that widow. She could get her loan in time. I beg your pardon, she couldn't get her loan in time, but she could get the loan to repay a money lender she had borrowed. As I said, sewing operations cannot be delayed at all, maybe day, 2 days, etc. Otherwise, you miss the bus. Now, another myth, as I said, was again put in a different way, that competition law and policy works for the rich and affluent. On one occasion, I remember in a meeting in a village meeting, we usually sit on the carpet on our haunches. And an old villager said that until import liberalization took place, I used to buy these battery cells for 6 rupees. Today I am getting it for 2 rupees, and I have been overcharged by 4 rupees. 4 rupees was a lot of money for that poor man. Maybe it just bought me a bottle of Coke, but for him it could buy a whole meal. And why was I being cheated all this while? So the realization of these people at that level that, look, you require competition through various means and not just checking anti-competitive practices, but the fact is that will it benefit the poor? Of course it will. Any competition reform will benefit the poor in one manner or the other. And any kind of anti-competitive measure which exists has always been seen to have burdened the poor the most. The poor are always the most vulnerable in any case in our society. Another myth was there was no public participation, which is again we argued against it, that there was. Then another myth which came up was that we have a competition law, as I said, the Monopolies and Restricted Trade Practices Act, and why do we need a new competition law? Again, there was argument was that there are 2 different concepts in terms of competition law and competition policy. Australia has both, by the way. One of the very rare countries in the world, and few other African countries have now followed this model, that they are drafting a competition policy and then getting into a competition law. And in between they carry out an audit of the various legislations which have an anti-competitive effect. So now there are problems in terms of the kind of other policies of the government which lead to anti-competitive outcomes. But what is the way forward? Is to carry out a competition impact assessment of the other policies, either at the request of the particular department or ministry, or suo motu. I mean, it could be done by the competition authority on its own accord, with its own thinking, or through information or requests made by anybody in the society. That has now started happening in India. We still don't have any particular case, but the process has now started taking place. So, I mean, that's good news as such. Now, We have also, with the help of the Australian government, including my dear friend Alan Fells, who's sitting behind, we've been able to draft a national competition policy for India in 2011, of which I was, Government of India had set up a committee of which I was a member. And unfortunately, the government changed, and the new government somehow doesn't feel that we require a policy statement. But as I said, one of the important aspects of the policy is that how do you check policies which are drafted or adopted which have an anti-competitive effect. So that has already started happening in a way. Secondly, there are many pro-competition reforms which are happening. One of them is the biggest pro-competition reform is the goods and service tax. India is a country with 32 states, including union territories, what is similar to your capital territory here, about 7 or 8 union territories. And they are union territories for various historical reasons, other than the national capital, Delhi, which is also union territory. So you can well imagine the kind of disparities which exist in terms of legislations. The implementation of the same law I have seen in one case 5 different approaches in 5 different states. So you really don't have anything which is uniform in that sense. And what we are trying to do is to build up a sort of policy coherence. And one of the things in that area was to have a goods and service tax so that it can reduce interstate, I would use the word bad competition, in the sense that, quite often, I know today friends of mine in Jaipur are buying cars in Gurgaon, which is next to Delhi, in a state called Haryana, because the sales tax is very low there on cars. So, you get these kind of distortions which happen, and and there's no bar on you keeping a car from another state in one state. There is a law which says that after, I think you've been there for 6 years or something, that you have to then apply for a local registration. But you don't have to pay sales tax if you wish to apply for a local registration in another province, for example. I mean, let's say, I don't know what is the system in Australia, but one can well imagine the kind of problems which can happen. So the goods and service tax is going to be a major competition reform, and more importantly also as a very major push on cooperative federalism, which did not exist in India. We are not a federation in that sense. India is a union of states, a quasi-federal structure, unlike the structure in Australia or US or Canada, or Germany, which are much more federal than India is. For historical reasons, and this is what the political consensus was at that point of time when the constitution was being drafted, that we require a unitary state. Historically, India has always been ruled by foreigners for thousands of years by dividing the people. So we require a unitary state if you want to hold on to the country as such. And therefore, the kind of political construct that we have is that the federal government we don't call it federal, we call it central government. And that is also colloquial in the sense that the Constitution of India doesn't have the word central government, it only talks about union government. But by usage, the word central government has become more popular, and that the word central as against union conveys the whole spirit of the idea that, look, the power is actually in Delhi and not in the states. Not a power. And therefore, like any other federal country, we have subjects which are divided in exclusive provincial jurisdiction, concurrent jurisdiction, or exclusive federal jurisdiction. I mean, we have those kind of divisions as well. And how all this will play out in the context of competition reform has to be seen. But as I said, what we have seen in these few reform measures which have been taken The Government of India is very keen to promote competition with the goal of accelerating economic growth and be able to create jobs. We don't have a very bad unemployment situation, but we have a large number of underemployed people in the country, and nearly 65% of our population are between the ages of 25 and 35. So there's a huge youth population which is all sort of surging out. And many of these youths, what we have seen particularly is that they do not wish to get into the traditional occupations of their parents. So a cobbler, or farmer, whatever. They would like to do something more, migrate to urban areas, which is urbanization is also taking place quite rapidly. Now, with that, I think my half an hour should be over.
Yes, I think we should wrap up.
Yeah. Thank you. So, in conclusion, let me sort of clarify as to why did the consumer movement take up the battle for a competition policy and law in India. A few pointers. In 1986, we were successful in getting a Consumer Protection Act. Under then the Prime Minister was a young fellow called Rajiv Gandhi. And most importantly, the Consumer Protection Act gave a fillip to the consumer movement because it recognized the role of a voluntary consumer organization to create associations as well as to be able to take up complaints of individuals as well as public class action suits before the Consumer Redressal Fora, which is what colloquially we call consumer courts. And very important, in 1986, as I said, the Monopolies and Restricted Trade Practices Act had an exemption for public enterprises, state-owned enterprises. But the 1986 Consumer Protection Act did not grant that exemption in spite of arguments made by the bureaucrats. And look, how can we do that? This is based upon the principle that the sovereign can do no wrong, and therefore public enterprises do not need to be regulated by any market law as such. One is not expected that they are going to abuse the consumer or abuse the market. So that, there was a whole change in paradigm in terms of economic governance, the 1986 Consumer Protection Act. Not only that, but it empowered consumer organizations to be able to take action under the Weights and Measures Act, the Agriculture Mark Act, and several other laws empowering the people to become prosecutors. If the state machinery doesn't do it, you as a consumer activist are able to do it. So there was a whole shift in that whole pattern. Now, unlike many other developing countries, the spirit of enterprise permeates the socio-economic fabric in India. So it was easy to convince people because the spirit of enterprise is not inimical to society in India, and therefore they were welcome to that. With the realization that an open and orderly market can promote consumer welfare and economic democracy, good governance, control of corruption, corporate citizenship, among others. And grassroots surveys have shown that people see globalization and liberalization as an opportunity with some short-term losses. We did a lot of work at the grassroots to find out as to what is the pulse. I gave you one example of an illiterate farmer saying that why am I getting this battery cell for 2 rupees now, and I used to get it for 6 rupees all these years. I mean, I've been ripped off. And how can prices fall when prices are rising up again? And until somebody had to tell him that, look, there is now free import. Otherwise, import was not free. Even I remember in the good old days, even a ballpoint pen was made in India by a small-scale sector, unprotected and turning out very shoddy stuff. Either the pen did not write or the ink leaked and people had their shirts were stained. And when import was allowed, following a dispute India lost in the WTO, that people started crying that, look, our small-scale enterprises are shutting down. So I said, fine, so if they are shutting down, they deserve to be shut down because they are producing shoddy goods. Does it mean that we should continue to support them? Is it to provide job for another 6 people? And people that the villagers realize this. So when we speak to villagers, I said, do you remember the ballpoint pen of the old days? Yes, we remember. Now you see the quality now. See the change. And this, now India being a big market, many of these foreign brands are now located, they're manufacturing in India. Because it has opened up. Otherwise, it was all reserved for the small scale sector. So, I mean, we had all these kinds of policy distortions which have been swept away by and by. I mean, in any country, you cannot have radical changes overnight. They have to be done gradually. And so this is another.